Welcome to the Bogosity podcast for the 2nd of November 2015, the podcast that plumps when you cook it. This is your host, Shane Killian. Let's disconsolate the news of the bogus. And we might as well begin with what everyone's been talking about this week, the huge, amazing finding of the WHO that the press is misrepresenting like a mofo, bacon and red meat cause cancer just like smoking does. What happened was, the World Health Organization classified processed meat as a Group 1 carcinogen, the same category as tobacco. But these categories can be confusing to people who don't understand how science and statistics work. It's the difference between p-value and effect size. The p-value is the probability that the measured effect is real. So if p is less than 0.05, there's a 1 in 20 chance that it's a mismeasurement, that the effect is outside of the margin of error. That is what the categories are based on. But that is not the same thing as effect size. All they're measuring is whether something has a sufficiently low p-value. But two carcinogens could have the same p-value, where one has a 95% chance of giving you cancer and the other only has a 1% chance. The p-value just says how likely it is we've measured each of those correctly. So this is from the WHO's International Agency for Research on Cancer, and they weigh this weight of the evidence on all sorts of things: foods, drinks, pesticides, smokable plants, anything that could be a carcinogen. It does not consider how much that substance increases your risk for getting cancer. So, processed meat and tobacco both cause cancer to about the same degree of certainty. But smoking increases your risk of lung cancer by 2,500%. If you eat 2 slices of bacon a day, that increases your risk for colorectal cancer by 18%. And even that's not as bad as it sounds. It's not like there's an 18% chance of getting cancer. It's that your risk relative to not eating bacon increases by 18%. In other words, your risk of getting colorectal cancer over a normal lifespan goes from 5% to about 6%. And as Alfred Nugent, oncologist and cancer epidemiologist at Columbia University, said, quote, "If this is the level of risk you're running your life on, then you don't really have much to worry about." So what they do is they divide carcinogens into 5 categories. Group 1 is carcinogenic, Group 2A is probably carcinogenic, Group 2B is possibly carcinogenic, Group 3 is not classifiable, and Group 4 is probably not carcinogenic. And yes, it's true that processed meat is in Group 1 along with smoking and asbestos and alcohol. It's also in there with sunlight. Because yes, sun can cause skin cancer. And if you get enough of it, it will. But does that mean you should avoid sunlight whenever possible? So we're not talking about risk assessment. We're not talking about the actual real-world danger you would face by this. And as has been remarked many times by experts, the only thing that will stop you from getting cancer is getting killed by something else. Say, if you're tired of the promos in this podcast, well, the patrons got it early and with no ads or promos. Just go to patreon.bogosity.tv and donate at any level. Hackers, terrorists, the NSA. But I repeat myself. Your online security is under attack, and the weakest point is your password. That's why you need LastPass. LastPass plugs into your browser and allows you to randomly generate strong, unique passwords anywhere on the web, all protected by one master password. LastPass sets up in minutes and gives you secure automatic logins throughout the web, synchronizing across all your browsers and all your computers, at home, at work, or on the road. It even securely stores sensitive form data, including credit card numbers, backup sensitive documents, membership info, Wi-Fi logins, and more. And with LastPass Premium, you can get these benefits on other applications and even mobile devices, and also get priority customer support. Sign up at password.bogosity.tv for a free month of LastPass Premium. Log in securely everywhere using the last password you'll ever have to remember. Go to password.bogosity.tv and get LastPass now. So one big issue we've had is with politicians and judges saying that the Bill of Rights doesn't apply to non-citizens, Even though the Constitution says they're rights of the people and is very clear about when rights only apply to citizens, like the right to vote. Now, the D.C. Court of Appeals has ruled that it also doesn't apply to citizens who leave the country because terrorism. According to David Ryan of Lawfare, quote, "The plaintiff, Amir Mashal, is a U.S. citizen and resident of New Jersey. According to the allegations in his complaint, he traveled to Somalia in 2006 to broaden his understanding of Islam, but fled to Kenya soon after because of violent unrest. In January 2007, a joint U.S., Kenyan, Ethiopian law enforcement operation apprehended him and transported him to Nairobi. Over the next 4 months, the defendants allegedly violated Meshal's Fourth and Fifth Amendment rights by secretly detaining and interrogating him, threatening him with torture and death, denying him access to counsel, and moving him across the borders of 3 African countries without legal process. The FBI eventually released Mashal, and the U.S. never charged him with any crime." So Meshal sued the FBI, citing a Bivens action, which is an action the courts have to remedy unlawful searches and seizures that occur during criminal investigations. Now, this should be a slam dunk, but there are a couple of issues here. First of all, Bivens has never been applied to anything extraterritorial, and second, it's never been raised in any sort of context involving national security issues. Now, of course, the Constitution doesn't say anything about either of those being any sort of exception. Nonetheless, the courts found that Meshal had no cause to seek damages under Bivens. Quote, "Meshal has no alternative remedy. The government does not claim otherwise. Meshal, backed by a number of law professors appearing as amici curiae, argues that, when the choice is between damages or nothing, a Bivens cause of action must lie. The Supreme Court, however, has repeatedly held that even in the absence of an alternative remedy, courts should not afford Bivens remedies if any special factors counsel hesitation." Of course, they gave pretty much no guidance at all as to what counts as a special factor, and that's the problem the court found with it. Quote, "If the courts, as amici argue, have radically misunderstood the nature and scope of Bivens remedies, a course correction must come from the Supreme Court, which has repeatedly rejected calls for a broad application of Bivens. Because we follow its lead, we will ship our oars until that court decides the scope of the remedy it created. If people like Mashal are to have recourse to damages for alleged constitutional violations committed during a terrorism investigation occurring abroad, either Congress or the Supreme Court must specify the scope of the remedy." In other words, not our problem, not our issue, we're passing the buck. Well, if you're thinking that this is a really bizarre argument, well, Judge Cornelia Pilliard thought the same thing, which is why she wrote in her dissenting opinion, quote, "Had Mashal suffered these injuries in the United States, there is no dispute that he could have sought redress under Bivens. If Mashal's tormentors had been foreign officials, he could have sought a remedy under the Torture Victim Protection Act. Yet the majority holds that because of unspecified national security and foreign policy concerns, a United States citizen who was arbitrarily detained, tortured, and threatened with disappearance by United States law enforcement agents in Africa must be denied any remedy whatsoever. In other words, your rights don't exist if what they're doing to you is in the interest of national security, or if it's on the other side of an imaginary line drawn on a map by bureaucrats. Your civil liberties just don't count when they're waging a war on terror."
Hi, I'm Dave. You may recognize me from previous Bogosity episodes. However, I'm not here to talk about that. I'm also part of a podcast, the Superplex Brothers Podcast. Head on over to superplexbros.com. You can check out the podcast for video games and pro wrestling. We also have news, reviews, and editorials and all kinds of stuff just to talk about video games and pro wrestling and everything else that comes in between. So if you're into that, why don't you come check us out?
John Brennan is the director of the CIA. You know, that organization dedicated to security which employs only the best of the best with the knowledge of protecting the United States from enemies of all kinds. And his email account got hacked. By a teenager. Now that would be delicious enough on its own, but the thing is, the emails were published on WikiLeaks, and there's a lot of embarrassing stuff in there showing that his actions weren't entirely on the constitutional up and up. Things like lowering restrictions on the CIA torture techniques we talked about last week. And Brennan is outraged by this. Outraged, I tell you! Quote, I was certainly outraged by it. The implication of the reporting was that I was doing something wrong or inappropriate or in violation of my security responsibility. And he criticized the media's, quote, ever-present thirst for trying to make something sexier and also of blowing it up more than it is. I think that's probably the only context in which anyone will ever use the word sexy in connection with John Brennan. But anyway, quote, that's why I am talking about the legal structures that we need, the investigative capabilities that we need. Because I see the role of government is to try to promote the security, the safety, the well-being, and the prosperity of its citizenry. If it does not have the ability to do that in this increasingly cyber environment, I think the government is not fulfilling its primary responsibility to the people. And what does that have anything to do with any of the problems that his emails show? If anything, maybe he should have promoted his own security of his own email account so this wouldn't have happened. Oh, but he's supposed to protect the rest of us too? Sorry, I think we'll do better on our own with strong encryption. It's amazing how outraged they always get by the leakers and the whistleblowers, but never by the torture and other atrocities they exposed. Now you can make Amazon purchases with Bitcoin by going to purse.bogosity.tv. That's P-U-R-S-E. Moreover, most purchases can be made at a discount. Save an average of 20% just by buying from Purse, or get even greater discounts by linking your Amazon wish list. Go to purse.bogosity.tv. Bogosity.tv is a participant in the Amazon Services LLC Associates Program, an affiliate advertising program designed to provide a means for sites to earn advertising fees by advertising and linking to Amazon.com. Just clear your cookies and go to amazon.bogosity.tv, or check the right-hand side of the podcast page for Amazon's best deals, including the deal of the day and limited-time lightning deals on all sorts of great products. So next time you buy online, go to amazon.bogosity.tv. And now it's time to puree this week's biggest Bogon emitter. And this week it goes to the U.S. Department of Justice, and yes, it's more Bogosity about strong encryption and the government bemoaning the fact that they can't spy on us when we use it. Well, the DOJ has filed a response to claims by Apple that it has no way to unlock an iPhone 5 and that making them do so would be unduly burdensome. The DOJ says that they can because although the consumer owns the physical device, they don't own the software. The software they claim is still owned by Apple. So this issue goes back to 2005, where Judge James Orenstein challenged an all-writs order by the DOJ. An all-writs order basically gives federal courts the authority to issue writs, or court orders, which are, quote, necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. In other words, it allows courts to require third parties to assist an execution of an order of the court. So think of a landlord helping police execute a search warrant by unlocking the tenant's door, that sort of thing. But Judge Orenstein challenged one of these all-writs orders by the DOJ, actually he challenged several of them, and he pointed out that governments using these particular orders in this way circumvented both the judicial system because it granted the judiciary powers Congress hadn't given them, and the legislative system, which didn't create any statute specifically authorizing the actions that were demanded. And none of that's changed a decade later. So this filing cites 3 other cases in which the FBI used an all-writs order to try and force the unlocking of an iPhone, and the DOJ argues that past successes should be future results. In other words, since they successfully violated our rights in the past, they should be allowed to do so in the future, with no response to Judge Orenstein's arguments. The filing also challenged Apple's assertions about how burdensome this is. The government says that Apple makes $100 million a day in profit, so how can the unlocking of one phone even begin to have a burdensome cost to them? Of course, it's not just going to be one phone, and we're talking about something that's difficult to do by design. We want it to be difficult for someone else to crack our lock screens. But the DOJ is arguing that while Apple may not own the phone, it owns the software, and specifically that lock screen software, which is part of the iOS operating system. Quote, Apple wrote and owns the software that runs the phone, and this software is thwarting the execution of the warrant. Apple's software licensing agreement specifies that iOS 7 software is licensed, not sold, and that users are merely granted a limited, non-exclusive license to use the iOS software. Apple cannot reap the legal benefits of licensing its software in this manner and then later disclaim any ownership or obligation to assist law enforcement when that same software plays a critical role in thwarting execution of a search warrant. What did we say, people? What did we say all those years ago when they started saying, no, you're just licensing the content, you're not really owning it? We warned about this exact sort of thing, people. Maybe one of these days you'll start listening to us. Hopefully the court won't buy this argument, but if it does, this will open the door for the government to issue all writs orders to access pretty much anything. Whether it's the software on your computer, because pretty much all operating systems operate under a license, or your phone, or whatever device you have, especially as we go into the Internet of Things. As more and more devices in your home become Internet capable, government will have more and more ability to spy on you just by issuing an all writs order. As Cory Doctorow pointed out, quote, virtually every commercial software vendor licenses its products rather than selling them. If the DOJ establishes the precedent that a product's continued ownership interest in a product after it is sold obliges the company to act as agents of the state, this could ripple out to cars and pacemakers, voting machines and tea kettles, thermostats and CCTVs and door locks, and every other device with embedded software. And as TechDirt put it, quote, the Internet of Things is now the web of government informants. The government's also complaining that going to the owner of the phone to unlock it is a, quote, unworkable option. The government wants Apple to do what they can't require the phone's owner to do, unlock it. And we've talked about this issue before. If you lock something with a passcode, government cannot compel you to turn it over, because that's a violation of the Fifth Amendment. Since it's something that you have to speak or write down, it counts as testimony, and they can't force you to testify against yourself. They can't force you to deliver any kind of testimony at all. Now, that might not be the same thing if it's sealed by a fingerprint or something like that, because they can collect fingerprints, that's part of gathering evidence. But actually typing in a passcode to bypass an unlock screen, well, the courts have ruled on that. Quote, the court's October 9 order suggests that the government might attempt to compel Feng to unlock the target phone, but that approach is also unworkable. Through counsel, Feng asserts that he has forgotten the passcode, which, if true, renders him unable to offer assistance. Even if Feng knew the passcode, attempting to compel him to unlock the target phone would not provide an adequate alternative to an order directed to Apple. Compelled decryption raises significant Fifth Amendment issues and creates risk that the fruits of the compelled decryption could be suppressed. The government should not be required to pursue a path for obtaining evidence that might lead to suppression. Oh, because we'll just have no choice but to violate his Fifth Amendment rights. Why are you forcing us to do that? Why are you making us do that, huh? We don't like doing that. Yeah, the mobster again. No, you can't do any of it. And if it's a violation to force him to unlock his own phone, how is it any less of a violation to force someone else to do it for him? Even if it's something that Apple mathematically cannot do. Apple has made it clear that they don't have the keys. Only the customer has the keys to decrypting the phone's contents. If the government wants in, that's the one they have to go to. Apple can't help them out. The government's just trying to bypass these Fifth Amendment protections, just like they've done with the Fourth already. But maybe that was part of the genius of the Constitution, because by repeatedly violating the Fourth Amendment, it's put them in the position of having to violate the Fifth as well. Multiple barriers, that's the key to security. The fact is, if they were actually behaving properly, if they were serving a proper and legitimate warrant to the device's owner, and they make them use the passcode to decrypt the device, they're violating the Fifth Amendment rights. That's what they said. They just admitted this. Forced decryption is a Fifth Amendment violation. Thank you, DOJ, for confirming that. So all of that makes the DOJ this week's biggest Bogon emitter. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. And now let's sandblast this week's
Idiot Extraordinaire!
And this week, it goes to the New York Times for insanely flawed and irresponsible reporting on nail salons, which has led to idiotic regulations that have harmed immigrants unjustly. And this was a two-part series written by Sarah Maslin Neer, which tried to tell this story of this horrible plight of manicurists at nail salons in New York City and Long Island, painting this picture of immigrant workers paid shockingly low wages while inhaling toxic fumes that cause miscarriages and cancer. Oh, how horrible and evil capitalism is. Well, Reason writer Jim Epstein spent several weeks reporting these aspects of Near's story, trying to confirm her facts and interview her sources. And he says, quote, "Not only did Near's coverage broadly mischaracterize the nail salon industry, several of the men and women she spoke with say she misquoted or misrepresented them. In some cases, she interviewed sources without translators despite their poor English skills. When her sources' testimonies ran counter to her narrative, she omitted them altogether." Already we're seeing hideously irresponsible journalism, but that's just the start of it. The day after the first article appeared, Governor Cuomo announced a new multi-agency task force to crack down on these nail salons. He issued an emergency order requiring them to purchase a wage bond, which means that if they're discovered underpaying their employees, the workers have some sort of resource to collect the difference. And the result of all this shoddy reporting is that, according to Aiming Feng, new nail salons used to open all the time in New York. They've stopped doing that. This has been a crushing blow to the business, especially the small businesses. It's also been a crushing blow for the untrained immigrants that they give those jobs to. Now many owners say they'll hire only legal workers who've completed an occupational licensing program because they're afraid of getting in trouble. So he reports that in September, 2 industry groups filed a discrimination lawsuit in New York State Supreme Court because they say they're singling out an industry that is highly dominated by Asians and Asian immigrants. Other groups have organized protests, holding signs that say things like, "Apology now, fire Near," and "Shame on you, New York Times, your lies kill our shops." And in July, Richard Bernstein, who used to write for the Times for 24 years, but left the paper in 2006, published in the New York Review of Books, "What the Times Got Wrong About Nail Salons." He pointed out that Near's story focused on only a small part of the industry and ignored the vast majority of nail salons, which pay well above the minimum wage and hire only licensed manicurists. He specifically challenged Near's claim that these Asian language newspapers have all sorts of manicurist ads offering all these shockingly low wages. Just fact after fact after fact that she got completely wrong. So what did the Times do? And this is the real crux of this. Did the Times apologize and publish a retraction? No. They penned a letter supporting Near's claims. And as Epstein explains, these Times editors mistranslated and misconstrued all the new evidence they put forth to support her, and that the evidence actually validates Bernstein. So in Near's story, she claims, quote, "Ads in Chinese in both Tsingtao Daily and World Journal for NYC Nail Spa, a second-story salon in the Upper West Side of Manhattan, advertised a starting wage of $10 a day. The rate was confirmed by several workers." Well, Bernstein decided to actually go looking through the classifieds in that same Chinese language newspaper, and he couldn't find a single ad that mentioned wages under $70 a day. He found one offering to pay between $110 and $130 per day. Now, of course, Near doesn't cite any specific ads, but she does say that she found so many so low they, quote, "appear to be a typo," Times editors Dean Paquette, Wendell Jameson, and Michael Luo co-signed a letter defending Near. Quote, one ad from June 19, 2014 in the World Journal, for example, showed a starting wage of $40 a day for small job. Another ad from July 17, 2014 in the World Journal also showed a $40 a day wage. Another one from April 17, 2014 showed a pay range of $40 to $90 a day. These examples were taken from a random sampling of days. Well, Epstein found copies of the ads and posted them, and they don't say what the Times editors claim they do. Two of the ads they cite say that a mani-pedi costs $40 at the salon, not that a worker is paid $40 a day. So why would they say how much a mani-pedi job costs? Because it means big tips. The first one translated says, quote, UV gel, big jobs, experienced small jobs, and cosmeticians. Flushing, pickup, and drop-off, mani-pedi $40 with commission, good percentage tips, may file taxes. And the second one reads, seeking UV gel experience, big jobs, small jobs, and cosmeticians, pick up and drop off at Flushing, mani-pedi $40 or more, expensive jobs. So the third ad the Times editors produced offered a wage of $40 to $90. So Bernstein interviewed David Lee, the salon owner who posted the ad. His shop went out of business in 2014 because he was struggling to attract qualified manicurists. And Lee said he was offering full-time workers a base salary of $90 per day and part-time workers $40 a day. So apparently they were just looking at the $40 pay and assuming that was for a full 8-hour day, when it was just part-time. Near also posted an image of the $10 ad to Twitter, but again, it doesn't say what she claims. It actually offers to pay manicurists not $10 a day, but $75 a day in base pay, and under that, it notes that apprentices or trainees can earn $10 per day. So it's just the apprentices, just the people getting on-the-job training, that are paid $10 a day. And according to the Times editors, quote, interviews by Ms. Near and her team with employees of the salon confirmed that these were essentially beginning workers doing the same jobs as others in the salon. But that turns out not to be true. According to former owner of the NYC nail spa, Yoon Jun Long, quote, we would never let them touch customers. If the customer is spending money, you can't stick them with an inexperienced worker. His salon went out of business a month after the Times story appeared, and he attributes that to the negative publicity. He's now helping to organize the protests. He says he offered the $10 to cover subway fare and lunch, and anyone who signed on could come and go as they please. They could work during slow periods practicing on other employees or get lessons from Long's wife and mother-in-law who are partners in the business. Long put Epstein in touch with a former trainee at the spa who only wanted to be identified as Jay. He confirmed that he never worked on a customer for the 2 weeks when he was making just $10 a day. And think of what a benefit this actually is to them, because they can get their training while making $10 a day instead of paying about $1,000 to complete 250 hours of formal training before getting a cosmetology license. Yes, this is one more huge problem with licensing. It destroys jobs and hurts the poor and eliminates the competition so that the big competitors can gouge the public. That's all it's ever been about. Now, the owner of Iris Nails, Alex Park, tried to defend his reputation after the article appeared, and according to Epstein, quote, the Times thwarted his efforts. The whole episode highlights the power imbalance between the Times and an immigrant community lacking in media savvy. Park estimates that his lowest-level employees earn about $180 a day, including tips, and his most experienced employees can earn as much as $400 a day, including tips and commission. Wow, how can I get one of these jobs? So Park hired attorney Daniel Kim to contact the Times and demand a correction, and they had a back and forth with the company's assistant general counsel David McCraw. According to Epstein, quote, the paper refused to alter the online version of the article, and it didn't investigate the truthfulness of Park's claim. Instead, Kim says, McGraw agreed that the Times would print a letter to the editor written by Park. Okay, so he gets his say in the newspaper, right? Well, here's the letter to the editor that he submitted. Quote, your recent article, The High Price of Pretty Nails, will damage my business, Iris Nails. It seems that you needed a nail salon in a well-heated neighborhood and targeted my business. I am preparing to retire after having worked for more than 22 years without any incident. Many of the employees in this type of services business have learned, earned, and moved on to open their own shops. I have always treated all of my employees fairly and never took advantage of them. There is no employee who receives $30 to $40 a day on a full-time basis. There is no employee who receives below the minimum wages required by the state of New York. In fact, most of our employees make double of minimum wages, including tips. Korean American business owners in New York are very hard-working people. We have dedicated our lives to whichever field afforded us an opportunity to prosper and live out the American dream. I write this letter with great sorrow and anger. Well, the problem is, the Times did print the letter on May 17th, but they edited it. They clipped out the sentences about there being no employee who receives $30 to $40 a day, no employee who receives below the minimum wage, and how most of their employees make double minimum wages, including tips. They cut those sentences out and added a new one saying, quote, I am committed to abiding by the law in paying my employees. Words that Park never wrote. And as Epstein points out, quote, the rewrite makes it sound as if Park was conceding that the Times reporting on his store was not only correct, but that it inspired him to reform his illegal practices. Times editor Sue Mermelstein said in a phone interview that there was an extensive back and forth with Attorney McGraw over the wording of the letter. Quote, and this is the quote inside the quote, we don't have the resources to go out and check the facts, she says, and we didn't want to let him make a statement that we felt was inaccurate. Give me a break. They make error after error after error, but when it comes time for the person that they smeared to do what they agreed to let him do and set the record straight, they cut out the part of his letter that actually does that. That is inexcusable. Now, the Times editors are also backing up Near's claims about all the violations. Quote, at last check, inspectors had issued nearly 1,800 violations after inspecting some 755 salons. In August, a newly created state multi-agency nail salon task force inspected 182 salons and found 901 violations. Well, in the first two sample inspections, the total hours each employee worked weren't recorded because they were paid by the day, which is an industry norm. It's also technically against the law, but that's what they want because they don't want to have their income fully recorded because they could become ineligible for government benefits. They might lose Medicaid or food stamps. So once again, we see the same kind of corruption that welfare always breeds. Well, since they couldn't get the total hours from the records, they interviewed the workers. Now, of course, the workers didn't have records either, so they just asked them to estimate. Give a range. About how many hours a day did you work? So when they gave a range, the inspectors took the highest numbers in the range and considered them working that many hours every day for every week over a period of several years. And that assumption pushed them into overtime territory, which meant they were entitled to 1.5 times the regular hourly rate. Now, what is that regular hourly rate? Well, since they were paid by the day, the inspectors had to determine that on their own. They went with a number higher than the legal minimum wage, which also increased the overtime rate. So they used the highball estimate for number of hours and assumed the workers worked those hours every single day, when in fact it was the high estimate, and they're assuming a base pay higher than minimum wage. Come on, they are not acting in good faith, not in any way. Also, the state inspectors didn't count most of the tips, which meant that they disregarded about 30% of what the workers were actually making. Epstein writes, quote, the minimum wage in New York State is $8.75 an hour, but in industries that rely on tips, the State Department of Labor requires a base hourly wage of at least $6.60 an hour. The state then considers the first $2.15 in hourly tips as part of an employee's compensation, but tips over and above $2.15 an hour aren't considered. And then you have this third sample violation letter where a manicurist said that she earned $75 in base pay and $60 in tips for every 10-hour workday. And that works out to $135 a day, which is $13.50 an hour. But the state only counted the first $21.50 in daily tips. They left that other $38.50 uncounted. If they had counted her entire compensation, the salon wouldn't have been fined and issued a violation. So that's the sort of thing you have to keep in mind whenever a newspaper talks about all these business violations. Yeah, they juggle the numbers to make them in violation even when they aren't. Sorry, that's what bureaucrats do. You can't trust them. So then there are Near's health claims. How one manicurist had a miscarriage, and another has had 5, and a third woman has a disabled child, and she also mentions nail salon workers suffering from sarcoidosis, thyroid problems, and breast cancer. And of course that must be due to all the fumes they're breathing in from nail polish and all the other substances they work with. But as Epstein points out, quote, "Careful readers will catch a grudging admission. A study looking for higher rates of cancer among nail technicians found no correlation. The study, which was published in the American Journal of Epidemiology in 2010, Cancer Incidence in Female Cosmetologists and Manicurists in California, 1988 to 2005, considered 9,044 cancer cases out of 325,228 licensed workers. It actually found that manicurists were less likely to get cancer than members of the general population. She also doesn't mention another study that looked at higher rates of adverse birth outcomes and maternal complications in cosmetologists and manicurists. It found no correlation. A different 2009 study published in the American Journal of Perinatology looked at the prevalence of conditions like postpartum hemorrhage and newborn intubation among cosmetologists. It also found a rate similar to that of the general population. In other words, whenever they do a study, they actually find rates of cancer and everything else that's similar to the rest of the population, which means that there's no reason to think that there's any fumes in the nail polish or anything that's causing these things. And the fact that there are all these manicurists that had miscarriages are just for the fact that women have miscarriages from time to time. They don't really have any more than we would expect if they were in any other profession. So then Near goes full food babe on what she calls the toxic trio: dibutyl phthalate, toluene, and, of course, formaldehyde. Well, 2 of those 3 chemicals aren't in nail products anymore, and that all 3 were only ever present in such a low concentration that they were never harmful in the first place. Remember, the dose makes the poison. So as Epstein says, quote, "Though dibutyl phthalate isn't used in nail polish anymore, it never had any negative health consequences on manicurists or their clients. Dibutyl phthalate has been shown to cause fertility problems in lab rodents in high doses, but as an EPA fact sheet makes clear, no studies are available regarding the reproductive or developmental effects of dibutyl phthalate in humans from inhalation or oral exposure." And he cites information from Doug Schoen, chemist and co-chair of the Professional Beauty Association's Nail Manufacturers Council on Safety, who said that the concerns by regulators over dibutyl phthalate had to do with its use in spray paint, which of course gets aerosolized and therefore breathed in a lot more. The second ingredient, toluene, isn't used in nail polish anymore because of food babe-esque scare stories. But as Schoen points out, quote, "When you pump gas once, you expose yourself to more toluene than you would if you sat in a room for the rest of your life filled with open nail polish bottles that contain the substance." And then we have formaldehyde, which is in nail hardener, about 1,000 to 2,000 parts per million. But as soon as the hardener touches the nail, the formaldehyde is broken down and isn't there anymore. So as Epstein writes, quote, "Near stokes fear over this fact, noting, quote, some of the chemicals found in nail polish are known to cause cancer. That's technically true, but it's misleading. There are carcinogenic chemicals all around us. It's the dose that matters. Formaldehyde is also present in every cell in our bodies and in our breath every time we exhale." So it's just like we were saying earlier. We know it's a carcinogen, but what is the risk factor for the amount of the substance that you're getting? And if you're not getting that much of the substance, then there's not that much of a risk. And as Schoen points out, quote, "If you tested many of the USDA's organic vegetables, you would find higher concentrations of formaldehyde than is present in nail polish in a salon." And while it is true that formaldehyde can cause a rare form of nasal cancer, according to Schoen, that's because people are exposed to, quote, "levels of formaldehyde hundreds or thousands of times higher than you'd ever be exposed to from using nail polish. To my knowledge, nobody has ever gotten cancer from nail polish." Now, the inexcusable thing about this is that Near interviewed Schoen on 2 occasions for a total of 2 hours, but the total amount she quoted from him was 2 sentences, and Schoen says that those sentences were completely out of context. After the article was published, Shun sent Near an email complaining that she had basically ignored everything he had said and had completely misrepresented the facts. She didn't respond. The fact is, this was never a health issue. All of these substances are safe in the doses they were exposed to. Epstein concludes, "The Times coverage is filled with internal contradictions and other red flags that should jump out even at those with no prior knowledge of the topic. Otherwise discerning readers suspended their better judgment, I think, because many believe the Times has such high editorial standards that if the paper's editors were willing to print such an outlandish story, it must be true. I don't think Near is the main culprit here. Every impassioned reporter needs to be reined in and challenged by a good editor. Why did editors Michael Luo, Wendell Jameson, and Dean Baquette allow the Nail Salon series to be published in the New York Times? And that's why the New York Times is undoubtedly this week's
Idiot Extraordinaire.
Well, that wraps up this Come On, Turn the Tape Over edition of the Bogosity podcast. As always, you can come to forum.bogosity.tv to read the show notes and join the discussion. This podcast depends on you to keep going, so please donate using the links on the website or at patreon.bogosity.tv, and feel free to join in by sending a question, statement, news article, or rant to podcast@bogosity.tv. You can even stick in an audio file if you want. Thank you for listening. Until next time, here's a quote from Mark Twain. If you don't read the newspaper, you're uninformed. If you read the newspaper, you're misinformed. The Bogosity podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 3.0 Imported License.
Bogosity.
Christmas time is coming, and the most classic of Christmas stories is A Christmas Carol. But how much do you know about the original Charles Dickens novella? Have you dismissed it as a children's book with one-dimensional characters amounting to nothing but platitudes and cliches? Maybe your appreciation of the book was even muted by those dry, boring, annotated books they made you read in school. My book, the sarcastically annotated A Christmas Carol by Charles Dickens, uses both facts and humor to present the book in a way you probably haven't seen it before. Giving praise when deserved and beratement when warranted, this book is put in the perspective of its time and shows a dimensional, multi-layered Ebenezer Scrooge from start to finish. Skepticism, history, and even economics are employed to show the book in relation to today in an easily accessible format. Appreciate the Christmas of your youth all over again. Get the sarcastically annotated A Christmas Carol by Charles Dickens, available at Amazon and on PDF as well.